Okay, let's unpack this. I want you to close your eyes for a second, unless you're driving, in which case definitely keep them open.
All right, good call.
But imagine you're driving. You're cruising down a two-lane highway. It's the mid-60s, maybe a little static on the radio. Your hands are at 10 and 2. You got your family in the car with you, and you also have a friend in the back seat.
Okay.
You decide to be a good citizen, a good Samaritan, and you pull over to pick up a hitchhiker.
It sounds like the beginning of a bad horror movie, or maybe a moral philosophy exam.
It gets worse.
Yeah.
Things go sideways almost immediately.
Yeah.
Your friend in the back seat, the guy you let in your car, pulls out a knife. He starts robbing the hitchhiker right there in your rearview mirror.
Oh, wow.
And here is the kicker. You, the driver, you don't panic, you don't scream, you don't slam on the brakes. You just keep driving. You say nothing, you do nothing. You just maintain your speed and stare at the road ahead.
Mm-hmm.
The question we need to answer today is, are you a criminal?
It is a terrifying scenario, but legally, it raises one of the most fundamental and tricky questions in criminal law. Can you be sent to prison for a crime committed by someone else simply because you were there, you saw it happen, and you didn't lift a finger to stop it?
Exactly. It feels like you should be in trouble, right? You're the captain of the ship. It's your car.
It feels that way, absolutely.
But today, we are going on a deep dive into a legal doctrine that says, maybe not. We were talking about the doctrine of accessory before the fact, and a very specific, somewhat controversial legal boundary known as negative acquiescence.
That is the term, negative acquiescence.
Ah,
It sounds passive, almost bureaucratic, doesn't it? But to understand it and to understand if you would go to jail in that driving scenario, we have to dissect a fascinating case from the Indiana Supreme Court called Pace v. State.
oh, okay.
This case is the perfect laboratory for testing the limits of liability.
So what is our mission here? What are we trying to solve for the listener?
Our analytical path is to determine the precise line between being a cowardly bystander and being a criminal accomplice. We are going to distinguish between mere presence at a crime scene.
Which you're saying is generally not a crime.
Exactly. Spoiler alert, it's generally not a crime. And the affirmative conduct required for aiding and abetting.
And I know there's a twist in there about who is in the car with you,
Right.
right? Because relationships matter.
Correct. We will also analyze the duty exception. This is the critical carve-out where doing nothing does become a crime based entirely on your relationship with the victim. It's where the law decides that silence is actually a form of action.
All right, let's get into the doctrine before we get to the story. We need to define our terms so we're all speaking the same language. In the context of this source material, what exactly is an accessory before the fact?
So an accessory before the fact is a legal term of art. It refers to someone who aids, abets, counsels, or encourages the commission of a felony, but isn't necessarily the one holding the weapon or, taking the wallet. In modern terms, we often just call this accomplice liability. The core concept is that you share the criminal intent, the common design or purpose of the main perpetrator. You are part of the team, even if you aren't the star player.
Okay, common design.
Yeah.
That sounds active. It sounds like planning, sketching out a map, agreeing on a signal. But our topic today is about inaction. What is the general rule when it comes to just standing there?
The general rule is that mere presence is not enough. Simply being at the scene of a crime, even if you know a crime is happening, does not make you a criminal.
So you could just watch a bank robbery.
You can stand on a street corner and watch a bank robbery. You can watch a fight break out in a bar. Unless you participate, the law views you as a witness, not a participant. To be an accessory, there has to be evidence of that common design we just mentioned.
And this brings us to that fancy phrase you used earlier, negative acquiescence. It sounds like something a teenager does when you ask them to clean their room. What does the law actually say about that?
Well, this comes from a precedent called Mattingly v. State. The rule is that negative acquiescence, which essentially means passively allowing the crime to happen without interfering, is insufficient to convict someone of aiding and abetting.
The not my problem doctrine.
You could call it that, yeah.
Yeah.
You can disapprove of the crime, or you can even silently approve of it and be happy it's happening. But if you don't show that approval through acts or words, the law generally can't touch you.
That's like a huge loophole. It feels morally wrong. Is there ever a time where silence is a crime? Where the law says, hey, you have to speak up?
Yes, and this is crucial. It's the exception derived from a case called Mobley v. State. The court ruled that failure to oppose a crime can be considered aiding and abetting, but only if the bystander owes a specific legal duty to protect the victim.
Like a lifeguard watching a swimmer. Or a bodyguard.
Exactly. Or, more commonly, a parent protecting a child. If you have a duty to act because of your relationship, your silence implies consent.
And if you have no duty.
If you have no duty, your silence is just silence.
Okay, we have the framework, we have negative acquiescence versus affirmative conduct, and we have the duty exception. But abstract rules are one thing. Real life is messier. Let's see how this actually plays out. Let's analyze Pace v. State.
Let's do it.
First, let's set the stage properly. What are the legally dispositive facts?
The facts are straightforward but dramatic, almost like a noir film. The year is 1967. The appellant, Carl Pace, is driving his car from South Bend to LaPorte, Indiana.
Okay.
Now, picture the car. It's a family trip. Pace is driving. His wife is in the front passenger seat. They have their 2 infant children with them. It's a full house.
A full car for sure.
But there's also another man in the car, a guy named Eugene Roots.
So we have Pace, the wife, 2 babies, and this guy, Roots. That is a crowded car. Where is everyone sitting?
Pace is behind the wheel. His wife and 1 kid are in the front. Roots is in the back seat with the other kid. Now, here is a detail I love. While they're still in South Bend, Pace asks his wife for permission to stop.
For permission.
Yeah, he sees a hitchhiker, Mr. Ruppert. Pace asks his wife if it's okay to pick him up.
Wait, he asks his wife for permission? That paints a picture of a guy who is considerate, right? He's not some rogue criminal mastermind. He's checking with his spouse before bringing a stranger into the family car.
Precisely. It establishes a baseline of normal, lawful behavior. So she says yes. Pace pulls over. Ruppert, the hitchhiker, gets in the back seat. So now in the back, you have Roots, the hitchhiker Ruppert, and one of the Pace infants.
Talk about a claustrophobic crime scene. So the victim, the hitchhiker, is in the car. What happens next?
The crime. As they are driving down the highway, Roots, the friend, pulls out a knife. He holds it on Ruppert. He forces Ruppert to hand over his wallet. They keep driving. A bit later, Ruppert gets out of the car, presumably terrified, and before he goes, Roots takes his watch too.
And the crucial detail. What did Pace, our driver, do while his friend was robbing a hitchhiker at knife point next to his own baby in the back seat?
That is the key. Pace said nothing. He did nothing. He didn't tell Roots to stop. He didn't pull over. He didn't call for help. He didn't try to alert passing cars. He just continued driving the car to LaPorte.
He just kept driving. That is wild to me. Imagine the tension in that car. Your friend has a knife out, a stranger's being robbed, your baby is right there, and you're just signaling a lane change.
I mean, yeah.
Okay, so Pace gets charged as an accessory before the fact.
Yeah.
And what was the core legal issue?
The legal question the Indiana Supreme Court had to answer is this. Is evidence of a driver's negative acquiescence, meaning his mere presence and failure to oppose a robbery occurring in his own vehicle, sufficient to sustain a conviction for being an accessory before the fact?
It's a test of the boundary between bad morals and bad laws. Now, we're going to break this down using the court's own logic. What rule of law did the court apply? Please state the full Black-Letter rule and break it down into its testable elements.
The court synthesized the rule from those previous cases we discussed, Mattingly and Mobley. So the rule for establishing accomplice liability in this context has 3 distinct components.
Okay, 3 parts.
Element 1 is presence and knowledge. The defendant must be at the scene and aware of the crime. Element 2 is affirmative conduct. There must be acts or words demonstrating a common design, counseling, encouraging, inciting, or aiding.
And the third?
And element 3 is the duty exception. In the complete absence of affirmative conduct, silence or inaction is only culpable if the defendant owes a legal duty to protect the victim.
Thank you. That gives us our roadmap. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, presence and knowledge?
Well, the sub-issue here was simple. Did Pace know the robbery was happening?
Right.
The court looked at the facts. It happened in the backseat of his car. It involved a knife. The space was small. The court acknowledged that the jury could reasonably infer Pace knew the crime was being committed. He was physically present and he was aware.
You can't really miss that.
You can't drive a car and miss a knife robbery happening 3 feet behind your head. No.
So element 1 is met.
Technically, yes, but, and this is a but that saves him, the court rules that presence and knowledge alone constitute negative acquiescence. It is a necessary condition for liability. You can't be an accomplice if you weren't there, but it is not sufficient for guilt. You have to be there, but being there isn't enough. It's like osmosis. Just being near the crime doesn't mean the guilt absorbs into you.
Understood. He knew, but knowing isn't doing. Now, what about the second element, affirmative conduct? This seems like the place where the prosecution would try to nail him.
It is. Here, the court is looking for evidence of counseling, encouraging, inciting, aiding, or abetting. They scrutinize the record for any sign of active participation.
Like, did he nod? Did he say, get his money?
Exactly. Did he speed up to prevent an escape? Did he lock the doors? Anything.
And what did they find?
Nothing. The record shows Pace said absolutely nothing. He did not signal approval. He merely continued driving the car.
So no affirmative conduct.
The court found no evidence of affirmative conduct. They specifically noted that they look for acts or words from which a common design can be inferred. Silence does not fit that category. The prosecution tried to argue that driving was the act, but the court viewed driving as simply continuing his previous lawful action. He didn't do anything new to help the crime.
That seems to be the linchpin here. Just driving isn't aiding in the eyes of this court. But what about the third element, the duty exception? Surely, as the driver, the owner of the car, the guy who invited this hitchhiker in, he has some responsibility for the people in his vehicle.
You would think so morally, certainly, but legal duty is very specific. The subrule here, citing Mobley, is that silence or inaction implies consent only if there is a duty to protect. The classic example is a parent and child.
And here, what's the relationship?
Here, Pace was the driver. Reppert was a hitchhiker. They were strangers. The court found that Pace's situation did not demonstrate a duty to oppose the crime. He had no legal obligation to put himself in danger to protect a man he just picked up off the side of the road.
There's no driver-hitchhiker special relationship in the law.
Not in Indiana law, no.
So no affirmative acts and no special duty to act. And after analyzing all the elements, what was the court's final conclusion?
The holding was decisive. The court stated that the verdict of guilty was not sustained by substantial evidence. They declared it contrary to law.
So they threw it out.
Completely. The disposition was that the judgment was reversed, and the court effectively said the trial judge should have granted a directed verdict of acquittal right from the start. Pace walks free.
Wow. Reversed. He walks. That really highlights how high the bar is for the state to prove you're an accomplice when you haven't actually touched the evidence. The court basically said he was a bad friend to the hitchhiker, but he wasn't a criminal.
It does. It reinforces the idea that the law punishes actions, not thoughts or lack of heroism. It separates the legal code from the moral code.
But let's pressure test this. I want to see where this breaks, because I feel like there's a limit. I'm going to throw some visceral hypotheticals at you to test the boundaries of these rules. Affirmative conduct and duty.
Go for it. Let's apply the doctrine.
Hypothetical 1, the verbal encourager. Same facts, Pace is driving. Roots pulls a knife. But this time, while driving, Pace looks in the rearview mirror and says, "Good job, Roots. Make sure you take the watch too."
Ah.
He doesn't touch the knife. He doesn't touch the wallet. He just says that one sentence. Is he guilty?
That changes everything. This moves us from negative acquiescence to affirmative conduct.
Just with words.
Remember the rule from Mattingly. The court looks for counseling or inciting. By offering verbal encouragement, take the watch too, he has provided the necessary countenance or support. He has joined the common design. In this scenario, Pace is likely guilty of being an accessory before the fact.
Just because of a few words. That feels like such a small shift.
Words are acts in this context. They signal intent and encouragement to the principal offender. That is all the statute requires. By speaking, he is no longer just a bystander, he is a cheerleader for the crime.
Okay, let's try the other angle. Hypothetical 2. The silent parent, same facts as the original case. Pace says absolutely nothing. He just drives. But the victim in the back seat isn't a hitchhiker.
Okay.
It is Pace's own teenage son, and Roots is robbing him. Pace watches it happen, hands on the wheel, and does nothing.
This is the nightmare scenario. This triggers the Mobley exception, the duty exception.
But he's still just silent. He's doing the exact same thing he did in the actual case.
Because the relationship changes the legal meaning of the silence. A parent has a fundamental legal duty to protect their child. In the eyes of the law, if you have a duty to stop a crime against your charge and you choose to stay silent, your silence is interpreted as assent. You are effectively saying, I agree with this. Failure to interfere when one has a duty implies consent.
So he would be guilty.
So, even without saying a word, Pace would likely be guilty of aiding and abetting here.
That distinction is fascinating. The relationship changes the meaning of the silence. Silence in a vacuum is nothing, but silence from a father is permission.
Precisely. Context is king in law. Silence in a stranger's car is indifference. Silence when your child is in danger is complicity.
This is really clarifying. It takes a messy situation and puts it into a grid. So for the listener who wants to be able to spot this in the wild or maybe on a law exam or just arguing with friends, how do we synthesize this?
If you are trying to analyze an accessory or accomplice liability situation, you need a diagnostic checklist. Based on Pace, Mattingly, and Mobley, here's the process you should run through.
Walk us through it. Step 1.
Step 1. Check presence. Was the defendant at the scene? If no, stop talking about aiding and abetting. You're looking at different crimes, maybe conspiracy or accessory after the fact. If yes, they were there, proceed to Step 2. Step 2. Check for affirmative conduct. This is the big filter. Did they say words of encouragement? Did they perform physical acts to assist? Look for any outward sign of support, a nod, a word, a blocked exit.
And if you find it.
If the answer is yes, liability is likely established, you are done. But if the answer is no, if you have absolute silence or inaction like Pace, you must proceed to Step 3.
Which is?
Step 3, check for duty. Does the defendant have a special legal relationship with the victim? Parent-child is the big one, but could be lifeguard swimmer, captain passenger, maybe teacher-student.
And the diagnostic result.
If yes, they have a duty, then their silence constitutes aiding and abetting. They are guilty. But if the answer is no, no affirmative acts and no special duty, then the conduct is legally defined as negative acquiescence. Under Pace v. State, this is not a crime.
It's a flowchart for freedom or prison, depending on your choices.
That is exactly what it is. It prevents the state from overreaching. We don't want to jail everyone who is just scared and freezes up, but it ensures that those who truly encourage crime or abandon those they must protect are held accountable.
So what does this all mean for us? The big takeaway seems to be that the law doesn't force you to be a hero.
That is the so what. In this context, it is not a crime to be a bad Samaritan. You can watch a crime happen, know it's happening, and do absolutely nothing, provided you don't help, and provided you don't owe the victim a specific duty of care.
It's shocking.
It might be morally repugnant to some to just keep driving while a hitchhiker gets robbed, but it is legally permissible.
It creates this strange reality where you can drive a robber to his destination knowing what he did, as long as you didn't help him do it.
Well, be careful. Driving him away might implicate you as an accessory after the fact or involved in the escape, but during the crime. If you are just continuing your pre-planned course like Pace was, the court says that isn't helping. It's just not stopping.
It's a razor's edge. And that's what I want to leave you with today. The court legally cleared Pace. They said the evidence wasn't there. But they also explicitly said they aren't drawing hard and fast rules and that every case depends on its facts.
True. One different fact could have tipped the scales.
So ask yourself this. At what point does just driving become facilitating a getaway? If Pace had driven a little faster to help Roots get away, if he had taken a sudden detour down an alley to avoid a police cruiser he saw, the line between negative acquiescence and active driver of the getaway car is incredibly thin. Pace stayed on the Roots side of it, but only just.
It is a line I wouldn't recommend anyone else try to walk. The view from the back seat isn't worth the risk.
Yeah, absolutely. Drive safe, everyone. And maybe be careful who you pick up and who you bring with you.